Some court hearings. Everyone is innocent until proven guilty in a court of law. The commentary and editing provided in our videos are in line with the principles of fair use, as outlined in Section 107 of the United States Copyright Law. So sit back, relax, and enjoy this video. Don't forget to smash the like button, pounce on the subscribe to get our latest content, and comment with the timestamp of your favorite moment.
Go ahead.
All right, your name, sir?
Roberto Siragusa Figueroa.
Roberto Siracusa Figueroa.
All right, sir, you're here today because you're arrested for the following charges: possession of a controlled substance without a prescription, possession of cocaine, possession of fentanyl, possession of methamphetamine, and tampering or fabricating physical evidence. I've read the charging affidavits. I do find sufficient probable cause. I'll set bond as follows. On count one, $1,000. Count two, $1,000. Count three, yep.
I believe he qualifies for PTR.
Okay, set a bond. We'll see what he wants to do.
Okay.
Possession of methamphetamine, $1,000, and tampering will be $500. You also qualify for pretrial release if you wish to have that. You wouldn't have to post those bonds, but you do have to check in with your pretrial release officer on a periodic basis. Which one would you rather have?
Esa es la que me dijo, la segunda que me dijo.
The second one.
All right, we release with pretrial release conditions. You're not to use or possess any guns, weapons, drugs, or alcohol, and we'll appoint a public defender to represent you. And that's it for the Spanish. That case was 2025. Let's see. CF 15197AO. And that's it for the Spanish.
Thank you, Your Honor.
Thank you. Have a good day.
No problem.
Hello?
Oh, hello. Are you there?
This is Fanny's ID 401179. I'll be your Haitian crew interpreter today.
All right. Have you been sworn today?
Yes.
Okay.
Your
All right,
Honor,
sir. Your name?
Monsieur Nom,
Jeffrey Sibis.
Jeffrey Sibis.
All right, sir. You're here today because you're arrested for a charge of resisting without violence. I have read the charging affidavit, and I do find sufficient probable cause.
Ok, yo arrête parce que résister sans violence et moi li rapport yo, moi joine yo gen cause probable.
Your Honor, there was a offer conveyed to my client. I was unable to advise him because of the language barrier, but we would be. I would like the court to advise him for
What's the offer?
withhold credit time served.
All right.
In the alternative, you would probably qualify for PTI.
All right, Mr. Sipis, the offer in your case, if you want to resolve it, is a plea of no contest, and it would be time served. So you would be released. Is that, and court cost.
Ok, pour résoudre dossier là, yo offrir ou ap juste lè ko servia et puis tout ou ap juste payer au tribunal là.
So if you want to enter a plea of no contest, you can do that today.
Ça veut dire si vous voulez entrer en plaidoyer sans contexte, ou ka fait ça jodi a.
Do you have any questions about what that means?
Est-ce qu'il y a une question qui ça veut dire?
Or unless, do you think you could afford a bond, sir?
Est-ce qu'on connaît si ou ap ka payer caution là? Hello?
Can somebody help you pay a bond?
Est-ce qu'on moun ka aider payer caution là?
Or you can resolve the case, sir. I just want to lay out your options.
Ou bien on ka résoudre dossier a? Listening to I'm having hard time hearing him, Your Honor.
And, Your Honor, this may be a non-issue. I believe PTR advised that he has an immigration hold.
Oh,
I believe
yeah.
they-
So, but the other thing is too, Mr. Sippis, there is a hold on you for immigration status.
Ok, gon lot problem ankon, yo gen yon imigrasyon ap kenbe ou, parce yo gen yon sakre li hold sou.
So even if you were to enter a plea on the case today, that you would not be released until they can determine what your status is for immigration purposes.
Mem si ou ta entre yon plaidoyer jodi a, yo pa ta prelache ou, jiska ske yo ta konen stati imigrasyon.
Your Honor, could we just set a bond so we could have more time?
Yeah, I'll set bond the amount of $500. He's
Ke ma
not,
meton kosyon pou $500.
defendant is not to use or possess any guns, weapons, drugs, or alcohol.
E moun ki fe nan pa sepose gen ken zam, ou bien nepot bay ki pou fe moun mal, alkol ou bien drog.
And I will appoint a public defender to represent him.
E nap appointe yon public defense pou reprezenter ou.
Alrighty, thank you, sir.
Ok, merci, monsieur.
And the next one's also Creole. Yep, we have one more. No?
Ken
That's it.
bon lot
Oh,
ankon?
no, we're all set. Thank you, ma'am.
You're so welcome. Thank you for using your service. Have a nice day.
Okay, bye-bye. So this is who we are, Francisco. What do I need for this one? All right, hello, sir. Your name?
How you doing, sir? My name is Francis Daniel Gouger, N-J-A-O-J-I-A.
How did you say that? How do you pronounce it?
Gouger.
Really?
Yes, sir.
That's interesting. So it sounds like a G, but it's NJ?
Yes, sir.
Okay, where is that from?
West Liberia, that's where my family is from.
Oh, okay.
Yes, sir.
All right, well, you're here today on for failing to appear on a petty theft in front of Judge Cameron. There's a bond of $1,000 on that.
Your Honor, there was, I believe that, can you turn that around? Mr.
Gouging.
Yeah, oh, that's why it was messing with me. It starts with an N. There was an offer conveyed to him, Your Honor. I just want to confirm that he had no open cases anywhere else. All right.
Oh, this is it.
It was messing with me.
The offer that was conveyed was an adjudication of guilt, credit for time served. There's cost investigation to OPD in the amount of $72, and there's a no return to the Walmart at 5991 South Goldenrod Road in Orlando.
All right, so Mr. Gouging, if you wish to enter a plea and resolve it today of no contest, it would be an adjudication of guilt, so it's conviction, time served, and then court costs and that cost of investigation. I'll give you 12 months to pay that.
Yes, sir.
Is that what you want to do?
Yes, sir.
All righty. Are you under the influence of any drugs or alcohol?
No, sir.
Suffer from or been treated for any mental illness in the past?
No, sir.
All right, go ahead and sign your form. And you understand this is punishable by up to 60 days in jail and up to a $500 fine?
Yes, sir.
All right, I'll accept your plea, and I'll sentence you to time served. I'll judge you guilty and be sentenced to time served. It'd be court costs, cost of prosecution, and a cost of investigation of $72 to OPD. That's gonna be about $350, something right in that range. And I'll give you 12 months to get that paid. You can pay a little at a time or all at once, as long as it's paid at some point in the next 12 months.
Yes, sir.
All righty?
Yes, sir.
You'll be released as to this today. Take care.
Bless you, sir.
You too.
Do we know how much credit he has?
Oh, what's the credit on that? 2?
Should be more.
Well, maybe, probably.
So,
I can check it.
It was a notice to appear, so it's a 1 or 2? Oh, I didn't hear you say two.
Two.
She said two. I didn't hear her say it. She's like, you know, you don't believe me?
Thank you.
Okay. Good afternoon.
Good afternoon, sir. This is Hanin, Tigrinya interpreter.
All right. Have you been sworn today?
Yes.
All righty. Sir,
Yep.
could you please state your name?
My name is
Salam.
Iyasu Barakat.
All right, sir, you're here today because the state you were arrested for a charge of driving while under the influence of an alcoholic beverage or chemical substance.
أوه أبزلوم زلخا ممتي خالومي عبتحت تغندي تخصيص كارلو زلخا ماكينة عبتحتي سخران الكول ويكال كما موسيتكا سخير كاخلخا سلزور كايو.
I have read the charging affidavit, and I do find that there's sufficient probable cause. I will set bond at $500.
أوه أتي مرتعوتات زغربوا بملو قبول كوينو سلزرخب قوة سلزي $500 كم عبز بانكا زي كفل جن كم واحد عبز بانكا تصنح بونت أخلاق لك كلاك أكاي.
If you do bond out, you're not to use or possess any guns, weapons, drugs, or alcohol.
سلزي السخان ترعنت أو تي كالومي بزي بوند وي بزي واحس $500 زخونة أتوار برد الكولاوي مستن ويون حشيش كتوسد يبلكان مسخة.
You're not to operate a motor vehicle without a valid Florida driver's license.
نسخة زخونة ماكينة كتمرح يبلكان بزي ممحف عد ماكينة.
And I will appoint a public defender to represent you so you'll have an attorney.
أوه بتوسخي أخبار حكي أبغى قصر الكائن عخا زحق زكا كتابة غلقة.
Now I will let you know that there is an immigration hold on you. Is there?
Doesn't have one, Your Honor.
It's not. Okay. No, I'm wrong about that. So you can bond out.
سلازي كتوجه تخيلي خانتها.
Alrighty, good luck.
أبو عدل.
That's it for him, right? Good to go. Thank you, sir. Appreciate your services.
You are welcome, sir, and thank you for using our services.
Who's this? Is this Marco Julio? Hello, good afternoon.
Olá, boa tarde. Good afternoon.
Have you been sworn today, sir?
Yes, the previous person swore me in.
Alrighty. Sir, your name?
Marco Antonio Julio.
All right, Mr. Julio, you're here today for arraignment on your no valid driver's license charge.
Certo, senhor Júlio, você está aqui para o comparecimento perante a questão de estar sem carteira de motorista.
Your Honor, there was an offer conveyed to my client. We will not be going forward with it. We'd like to enter a plea of not guilty and schedule him for a pretrial conference.
All right, we will enter a not guilty plea. We'll set that for pretrial in Division 83.
Certo, excelentíssimo. Nós não estaremos seguindo adiante com o julgamento. Nós vamos colocar um pedido para que não haja culpa para inserir ao julgamento. E ele falou assim, então nós não vamos dar continuação. Vai ser feito um pré-julgamento na divisão 83.
All right, sir, your attorney will come out and see you before the pretrial.
Certo, senhor, o senhor advogado vai estar falando com você antes desse pré-julgamento.
Thank you. right, thank you, sir.
You're welcome, Your Honors. Anything else I can do for you today?
I think that's it.
Thank you
Madam
for using your services. Have a good one. Bye.
Signed it twice. Yep. Saw a line and went for it. Your name, ma'am? I'm Dobbs. You're here today because you're arrested for a charge of possession of methamphetamine. I have read the charging affidavit. I do find sufficient probable cause. Bond, we set an amount of $1,000. If you do bond out, you're not to use or possess any guns, weapons, drugs, or alcohol, and you are not to, and I'll appoint a public defender to represent you.
Thank you. With it being set for a $1,000 bond, could I proceed with the 10% and get myself out tonight?
I just talked to, that's a contractual thing between you and your bondsman. Generally, that's the way it works, yeah.
Thank you.
You'll have to talk to them. Your name, sir? Last name? All right, sir, I have, you've been arrested for the charge of...
I apologize, Your
I have read the charging affidavit. I do find sufficient probable cause for the charge that you were arrested. State?
Your Honor, it is a first-degree felony that is punishable by life. We are requesting that he remain at no bond. It's also an enumerated dangerous crime under 907-0415D. We're requesting that he remain at no bond, pre-trial detention date, no contact with the victim, and no return to any Disney property.
All right. So there will be a no bond. I'll set that, we'll have that set for a pretrial detention hearing.
It'll be November 25th at 9 o'clock, courtroom 7B.
All right, condition also will be that you have no contact with the alleged victim, no return to Disney property. If he does have any personal items there, he can go back one time with a law enforcement officer. He's not to use or possess any guns, weapons, drugs, or alcohol. And I will appoint a public defender to represent you.
They're going to transfer you, okay? They're going to transfer you. You need to go for this hearing. Yeah, just follow them. Read that green slip. You'll get an attorney. Madam Clerk, what was that PTD hearing? It was November 25th? Thank you.
Your name, ma'am? Ms. Rucker, you're here today for two separate cases. First of all, in 2025 CF 12221 AO, it's based off of a probable cause warrant in that you were charged with petty theft, 2 or more prior convictions, and resisting an officer without violence. Looks like I see that there's a corrected. The bonds on that set by the judge are $750 on count 1, $500 on count 2. You're not to return to the store in the case. You are not to use or possess any guns, weapons, drugs, or alcohol. And I will appoint a public defender on that. And then the second case was a case in which you were arrested, charging petty theft with 2 or more priors and resisting a merchant. I did find sufficient probable cause on that. On that petty theft, the bond will be $1,500. The resisting a merchant will be $1,500. And I will appoint a public defender to represent you on that. You're not to return to the scene. You're not to use or possess any guns, weapons, drugs, or alcohol. You're not to contact any of the witnesses or the victim.
And the state does have a motion as to the 15176 case requesting it be transferred to 22 with that lowercase number.
Okay.
May I approach?
Mm-hmm. So you write in the date for me.
Try to make it easy for
She
you.
doesn't write it in. Brenda's like makes me fill that in. All right. Okay. What do we got here?
You could just read the failures to appear, Your Honor.
Your name, sir?
So,
Are you still represented by Mr. Rivas?
I don't know, I had Mr. Remus, then I had another Longwell,
Oh, yeah, it looks like actually even your case is set for determination of counsel coming up. So they must have withdrawn. Okay. This is for failing to appear, for failing to register or to report as required under the statute. There's 2 counts of that. There's no bond on either one.
Is there any way I could get on because I was in the other?
Do you need, well, it's set for determination of counsel on 12-3, so I'll just let it wait and we'll see what the judge does. He'll probably appoint you a lawyer at that point. You also, I'll let you know, it looks like there's a couple of holds for you from Hillsborough County. So when this gets resolved, they'll let Hillsborough County know you're here.
Okay.
No bond, yeah, and then, oh. Well, I think he's out because, hold on, what was his name?
I don't know if it's determined.
S-O-A. Because it said something about Longwell, I don't know. That's what it still says here. Let me see if there's anyone withdrawn.
Let's see.
I just leave it with that because I don't see order allowing him to withdraw. All right, your name, sir?
Kevin Michael Walker Jr.
Mr. Walker, you're here today because you were arrested for a charge of aggravated assault with a deadly weapon, possession of a weapon or ammo by a convicted felon. This was a probable cause warrant signed by another judge. State.
Yes, Your Honor, and as currently charged, count 2, the possession of a firearm by a convicted felon gang enhancement is a punishable by life offense. We are requesting he remain at no bond pursuant to Arthur on that count with no date. However, count 1, the aggravated assault with a firearm, is an F3 with use of force. Schedule is $5,000. We'd ask for $5,000 on 1.
All right, so as to count 1, aggravated assault with firearm, we set at $5,000. Count 2, remain at no bond due to enhancements, set for a pretrial detention hearing.
And Your Honor, there'd be no date due to it being an Arthur hold. We can't legally hold him pretrial detention.
Oh.
This is not an enumerated dangerous under pretrial detention. It's only a PBL under Arthur.
Okay. So no date. Appoint a public defender to represent you on that. You're not to use or possess any guns, weapons, drugs, or alcohol. No contact with any alleged victims or co-defendants if you do bond out. All righty. Which you can't, but. Your name, sir?
Paul White.
Mr. White, you're here today because you're arrested for the charge of burglary of a structure, petty theft, and possession of cocaine. This is based, where is that? Yeah, I have read the charging affidavit. I do find sufficient probable cause. As to the burglary of a structure, I'm going to set bond at $1,500. The petty theft is $500. And possession of cocaine would be $1,000. If you do bond out, you're not to use or possess any guns, weapons, drugs, or alcohol. You're not to return to the scene of at 651 West Michigan Street. Not to have any contact with any employees from the TK Elevator Company, and it will appoint a public defender to represent you. Well, how about that? All right, your name, sir? Oh, I'm sorry, Carla. Your name? All right, Ms. Baum, you're here today because you were arrested on a charge of trespass. I have read the charging affidavits. I do find sufficient factual basis.
There's no offer at this time.
All right, so upon the amount of $250. If you do bond out, you're not to return to the scene, not to have any contact with any witnesses. You're not to use or possess any guns, weapons, drugs, or alcohol, and it will appoint a public defender to represent you.
Zachary Landers is medical.
We'd ask to waive that, appearance, Your Honor.
Appoint a public defender, $250 fine, no return, no guns, no weapons, no drugs, no alcohol.
How much was the bond?
$250.
Okay.
Your name, sir? Your name?
Jesus Antonio Marquez Jr.
Hi, Mr. Marquez. You're here today because you're arrested on a charge of trespass. I have read the charging affidavit, and I do find there's sufficient probable cause, except on the amount of $250. If you do bond out, you're not to use or possess any guns, weapons, drugs, or alcohol. You're not to return to the scene, and it will appoint a public defender to represent you.
Just grab that.
Nichols, out of county. Nichols, out of county.
Bonded on that one, Joe.
Oh, he bonded.
Bonded, yes.
That's why you don't have it. I didn't have it either. Your name, ma'am?
Jessica Tijerina.
Mr. Renier, you're here today because you're arrested on a charge of possession of drug paraphernalia. I have read the charging affidavit. I do find sufficient probable cause.
Your Honor, there was an offer conveyed to my client. I just need a signature. She's been advised. She would like to go forward.
You want to enter a plea of no contest to that and resolve it? Yes. Is that right? All right. Are you under the influence of any drugs or alcohol? No. Have you suffered from or been treated for any mental illness in the past? Yes or no? No, all right. In this plea form that you just signed, any questions for me about anything on the form?
No.
And you understand this is punishable by up to a year in the county jail and up to a $1,000 fine?
Yes.
All right, I'll accept your plea. I will judge you guilty. You'll be sentenced to time served, which is 2 days. I don't know.
Yes.
2 days? Yes. 2 with 2. I'll impose court costs, $50 cost of prosecution. That's a total of $273. And you'll have 12 months from your release to get that paid. So you can pay a little at a time or all at once, as long as it's paid at least within 12 months of today's date. Okay? All right, you'll be released as to this case. Good luck. Your name, sir?
Gaspar Alexis.
Your Honor, my client has been, has an offer conveyed to him. We would just ask that the court take no action if he goes forward with the offer.
Please, that'll be it. All right, sir, so I have read the charging affidavit. I do find there's sufficient probable cause for the charge of open container. Your attorney, that indicates you want to enter a plea of no contest. Is that right?
Yes, sir.
Are you under the influence of any drugs or alcohol today?
No, sir.
Have you suffered from or been treated for any mental illness in the past?
No, sir.
This plea form you signed, any questions for me about anything on the front or the back?
Yes, sir.
Yeah, no, or yeah? You have questions or no questions?
No questions.
All right. And you understand this is punishable by up to 60 days in jail and up to a $500 fine?
Up to.
Yes, sir.
All right, I'll accept your plea. I'll judge you guilty. You be sentenced to time served. I'll impose court costs of $223, and you'll have 12 months to get that paid. You can pay a little at a time or all at once. You'll be released as to this case.
Yep. Mhm.
Your name?
Stephen Cook, sir.
Hi, Mr. Cook. You're here today because you were arrested on a charge of open container. I have read the charging affidavit. I do find sufficient probable cause.
There was an offer conveyed to my client. He would like to go forward. I just need a signature.
Okay. So, Mr. Cook, you wish to enter a plea of no contest to the open container?
Sir.
Okay.
It was 5-2.
Are you under the influence of any drugs or alcohol today?
No, sir.
Have you suffered from or been treated for any mental illness in the past?
No, sir.
And this plea form that you just signed, do you have any questions for me about anything on that form?
No, sir.
You understand that this is punishable by up to 60 days in jail and up to a $500 fine?
Yes, sir.
All right, I'll accept your plea. I will judge you guilty. You'll be sentenced to 5 days in the Orange County Jail. You do have 2 days credit. I'll impose court costs of $223, and you'll have 12 months from that, the date of your release to get that paid. You can pay a little at a time or all at once.
Yes, sir.
All righty, good luck.
They'll let you go. No, you're good.
Good afternoon. Your name, ma'am?
My name is Lavette Kopak.
Your Honor, I apologize. There was an offer conveyed to my client, Ms. Kopak. It was an adjudication, credit time served, and no return to the scene. She just needs to sign.
And Ms. Kopak, is that what you want to do?
Yes, sir.
Okay.
She has 1 day.
Right. Oh, it's a nice signature.
All right, ma'am, are you under the influence of any drugs or alcohol today?
No, sir.
Have you suffered from or been treated for any mental illness in the past?
No.
And the plea form you just signed, any questions for me about anything on the form, front or back?
Pardon me? Pardon me?
Any questions about the form you signed?
No question.
All right, and you understand that these are both punishable by up to 60 days in jail and up to a $500 fine? You understand?
No, sir.
That's not what's going to happen. It's going to be time served, but that's what the maximum could be on that. I just have to tell you that to make sure it's a knowing plea.
Thank you.
Okay? All right, I'll accept your plea. I will judge you guilty. It would be 1 day in the Orange County Jail with 1 day credit for time served. And I'll impose court cost of $223. And you'll have 12 months from today's date to pay that. You can pay a little bit or all at once, depending on what you want to do, as long as it's paid in 12 months. And you'll be released from on this case today.
Thank you.
All righty.
Not a problem, ma'am.
Got an offer?
He does. Can we reset him?
Yeah, I'll set him tomorrow.
Thank you.
Is it reset with
Outside medical, yeah,
of release?
within 24 hours.
Of release. Oh, so how would that work, Your Honor? It sounds self-explanatory, but what I
Well,
know,
if he gets back today, we'll bring him tomorrow. If it turns out that he gets out on Saturday, the person on Sunday will just go, how come you got
okay, so
reset?
it could extend into the weekend.
Yeah,
Okay. All right.
I'll appoint the public defender. All right, your name, sir?
Mitchell Garner.
All right, Mr. Garner, you're here today because you're arrested on a charge of open container. I have read the charging affidavit, and I do find there's sufficient probable cause.
The offer conveyed was an adjudication, 7 days. He has credit for 2 or 1.
Okay. So did you want to enter a plea of no contest and resolve your case, Mr. Garner? It's the offer from the state is 7 days jail with 1 day credit.
Yes, sir.
All righty. Are you under the influence of any drugs or alcohol?
No, sir.
Have you suffered from or been treated for any mental illness in the past?
No, sir.
In that plea form, any questions for me about that?
Yes, sir.
You do have questions or no questions?
I don't have no questions.
Okay, all right. And you understand this is punishable by up to 60 days in jail and up to a $500 fine?
Yes, sir.
All right, I'll accept your plea. I'll judge you guilty. You're sentenced to 7 days, excuse me, in the Orange County Jail. You do have 1 day credit. There'll be court cost of $223, and you'll have 12 months from your release date. To get that paid, you can pay a little bit at a time or all at once. All right? You're all set. Gone out and cleaned out the camp. You got a bunch. All right, your name, sir?
David Green Howard.
Your Honor, my client had an offer conveyed to him, adjudication, credit time served, no return to the scene. He would just need to sign.
All right, Mr. Green Howard, you were arrested on a camping charge. I have read the charging affidavit, and I do find that there was sufficient probable cause, but your attorney indicates you want to just go ahead and resolve it by entering a plea of no contest. Is that right?
Yes.
Okay. Are you under the influence of any drugs or alcohol?
No.
Have you suffered from or been treated for any mental illness in the past?
No.
And the plea form that you just signed, do you have any questions for me about anything that's on the form?
No.
And you understand this is punishable by up to 60 days in jail and up to a $500 fine?
Yes.
I'll accept your plea. I will judge you guilty, be sentenced to
2.
2 days with 2 days credit. I'll impose court cost of $223. And you'll have 12 months to get that paid. You can pay a little bit at a time or all at once. And you'll be released on this case today. Yeah, no, and no return. Don't go back where you were camping before. Thank you, sir. Your name, sir?
Yes, sir. Antoine Jones, sir.
All right, Mr. Jones, you're here today because you're arrested on a charge of camping. I've read the charging affidavit, and I do find sufficient probable cause.
And there was an offer conveyed to Mr. Jones of an adjudication of guilt and credit for 1 day.
All right, is that what you wish to do, is enter a plea of no contest to the charges?
Yes, sir.
Mr. Jones? Okay. Are you under the influence of any drugs or alcohol?
No, sir.
Have you suffered from or been treated for any mental illness in the past? And this plea form you signed, do you have any questions for me about anything on the form?
No, sir.
You understand that this is punishable by up to 60 days in jail and up to a $500 fine.
Yes, sir.
I will accept your plea. I will judge you guilty, be sentenced to 1 day in the Orange County Jail with 1 day credit for time served. There'll be $223 in court costs, and you'll have 12 months to get that paid from your release. So you can pay a little at a time or all at once, as long as it's paid in 12 months. All right? You'll be released as to that case today.
Yes, sir.
Oh, no, you're good. Y'all.
Yep, you're set. Your name, sir?
Raymond Jones.
All right, Mr. Jones, you're here today because you're arrested on a charge of camping. I have read the charging affidavit. I do find sufficient probable cause.
And there was an offer conveyed of a withhold of adjudication and credit for the 1 day.
All right, so if you wish to resolve your case today to time served to be a withhold of adjudication, is that what you want to do? You want to enter a plea of no contest?
Yes.
Okay. Are you under the influence of any drugs or alcohol today?
No, not at all.
Have you suffered from or been treated for any mental illness in the past?
No, not at all.
All right, and you, this plea form that you signed, do you have any questions for me about anything on the form? Any questions?
No questions whatsoever.
Okay. And finally, you understand this is punishable by up to 60 days in jail and up to a $500 fine. That's not going to happen, but that's what the maximum is. You understand that?
It's 60 days or...
No, you're not getting that. That's what the maximum is on that offense. You're not getting that. It's time served.
You'll be done
Okay.
today.
You understand that? Okay. I'll accept your plea. I'll withhold adjudication, so it's no conviction. Be 1 day in the Orange County Jail with 1 day credit, so you've already done it, so it's time served. I'll impose $223 in court costs, and you'll have 12 months from today's date to get it paid. You can pay a little bit at a time or all at once. But you'll be released on this today. Okay? All righty. Take care.
Good, eh?
Ceiling.
Your name, sir? Your name? Hello? Yeah, your name? All right, sir, you're here today because you're arrested on a charge of taking part in prohibited activities in a city-owned restroom facility.
And hear him?
Can't hear you, buddy.
You were arrested on the charge of prohibitive activities in a city-owned restroom facility. Sounds a lot more nefarious than really what it is, but, and I have read the charging affidavit. I do find there's sufficient probable cause.
There was an offer conveyed of an adjudication of guilt and credit for 2 days.
I can't hear him clearly.
How about now? Can you hear? Is that better?
Yes, sir.
All right. So you were arrested on a prohibited activities in a city-owned park. I have read the charging affidavit, and I do find there's sufficient probable cause. So the offer, if you wish to resolve your case, would be entering a plea of no contest. It would be an adjudication of guilt and time served. There is court costs of $223. Did you want to resolve your case today by entering a plea of no contest?
I would like to do that, my lord, but I want to correct something here because what you wrote, I've read what you wrote.
I didn't write anything.
I know, I'm talking about the arresting officer.
Okay.
What you wrote, I just want to correct something here. What you wrote wasn't the complete truth, okay? What he called a pile of clothes, just my hoodie and my jacket. And then what he says is bathing was just cleaning my face and my shoulder. That's what he saw when he came there. So
okay.
I'm trying to explain things. He insisted that I'm going to jail. So I said, okay.
Well, here's your options. If you want to, I'll set a bond for you, and you can proceed on it, or if you just want to just resolve it.
Yeah, I just want to resolve
Okay,
it.
understood. All right. So you want to enter a plea of no contest?
That would be fine, Judge.
All right, and a no contest plea is not an admission. You're not saying you did it. You're saying you think it's in your best interest to get it over with. Okay, so you're not admitting to anything. All right? Okay, are you under the influence of any drugs or alcohol today?
No, please.
Have you suffered from or been treated for any mental illness in the past?
Not at all.
All right, in this plea form, do you have any questions for me about anything that's on the form? Any questions?
No question. I've read
All right, and you understand that this is punishable by up to 60 days in jail and up to a $500 fine? Okay, I'll accept your plea. I will adjudge you guilty. You'll be 2 days in the Orange County Jail. You have 2 days credit, so you're done with your jail time. There's $223 court costs, and you'll have 12 months from today's date to get that paid. You can pay a little at a time or all at once, whatever you wish to do, but you'll be released from that case, this case today. Okay? All right, good luck.
Thank you.
I knew he was going to say that. I knew he was, yeah.
Your name, sir?
Kendrick Parker.
Mr. Parker, you're here today because you're arrested on a charge of open container. I've read the charging affidavit, and I do find sufficient probable cause.
And there was an offer conveyed of an adjudication and credit for 2 days.
So, Ms. Parker, do you wish to enter a plea of no contest if the offer is adjudication of guilt and 2 days with 2 days credit? This would be court cost. Is that what you wish to do?
Correct.
That means time served.
Correct.
Okay. Are you under the influence of any drugs or alcohol?
No, sir.
Have you suffered from or been treated for any mental illness in the past?
No.
That plea form that you signed, any questions for me about anything on the front or the back?
No, sir.
And you understand that this is punishable by up to 60 days in jail and up to a $500 fine.
Yes, sir.
I'll accept your plea. I will judge you guilty. Be sentenced to 2 days with 2 days credit for time served. There will be court costs in the amount of $223, and you'll have 12 months from today's date to get it paid. You can pay a little bit at a time, or you can just pay it all at once, up to you. Okay? You're all set. Your name, sir?
Stephen Popovich.
Mr. Popovich, you're here today because you're arrested on a charge of camping. I've read the charging affidavit. I do find sufficient probable cause.
And there was an offer conveyed of an adjudication of guilt and credit for 1 day.
So if you wish to enter a plea of no contest, the recommendation from the city is that you be adjudged guilty, and then you be sentenced to 1 day with 1 day credit. So time served, and there's court cost of $223. Is that what you want to do, is enter a plea of no contest?
Yes, sir.
All righty. Are you under the influence of any drugs or alcohol today?
No, sir.
Have you suffered from or been treated for any mental illness in the past?
No, sir.
This plea form you signed, do you have any questions for me about anything on the form?
No, sir.
And you understand this is punishable by up to 60 days in jail and up to a $500 fine.
Yes, sir.
I will accept your plea. I will adjudge you guilty, be sentenced to 1 day in the Orange County Jail with 1 day credit for the time you've served. There'll be court costs of $223, and you'll have 12 months from today's date to get it paid. You'll be released from this, on this case today.
All right, thank you, sir.
Mhm.
We'd ask to waive that appearance, Your Honor.
All right, appoint a public defender, no return to the scene, bond of $100, no guns, no weapons, no drugs, no alcohol. All right, your name, sir?
Alexander.
Mr. Alexander, you're here today because you're arrested for number of charges.
Your Honor, just with one of the charges for Mr. Alexander, I couldn't find, this isn't a probable cause argument per se, but I couldn't find the aggravated assault on the law enforcement officer on the affidavit.
Pointing the firearm.
Oh, pointed at the helicopter.
Okay.
Did the helicopter land? Because it sounds like they were the first ones on the scene. When I read it, I was like, wow, did they just like drop that helicopter down?
I don't believe so, but I'm not sure based on the reading of the
All right. Okay. All right. So, Mr. Alexander, it's possession of cocaine with a weapon, possession of firearm by convicted felon, possession of weapon in commission of a felony, possession of ammunition by a convicted felon, possession of drug paraphernalia, aggravated assault on a law enforcement with a firearm, improper exhibition of a weapon or firearm, and possession of cannabis less than 20 grams. I have read the charging affidavit. I do find there is sufficient probable cause. As to the possession of cocaine with a weapon, the bond would be $1,500. Possession of firearm by convicted felon, $2,500. Possession of weapon in commission of a felony, $1,000. Possession of ammunition by a convicted felon, $1,000. Possession of drug paraphernalia, $100. Aggravated assault on a law enforcement officer with a firearm, $5,000. Improper exhibition of a weapon or firearm, $1,500, and possession of cannabis less than 20 grams, $100. If you do bond out, you're not to use or possess any guns, weapons, drugs, or alcohol. You're not to have any contact with any of the alleged victims. And I will appoint a public defender to represent you.
Thank you.
Your name, sir? Your name? Your name?
Can we waive the readings?
All right.
Charges, Your Honor.
All right, Mr. Pleas, you're here for two matters. First of all, in 2025 CF 15025. Right case now. You have it, but, and I read them, so. All right, and 15205, that case, the allegation, I have read the charging affidavit. I do find sufficient probable cause, and bond will be set in the amount of $2,000. If you do bond out, you have reporting requirements. You must report immediately or within 48 hours, excuse me. And then in the other case, which is a traffic case, it's a not having a motorcycle endorsement. Bond be set in the amount of $250. You're not to use or possess any guns, weapons, drugs, or alcohol, and you're not to operate a motor vehicle without the proper licensure on the streets of Florida. I will appoint a public defender to represent you on those. And then you have, finally, I don't have that one. What is that one? So I don't have- And also, there's a violation of probation out of county. There's no bond on that. So we'll let them know that you're here on that. If you bond out, if you don't bond out here, then we'll wait. But if you do actually post bond on the other two, then we will let the other county know. They'll either come get you or they'll tell us to cut you loose. Your name, sir?
Chanel Brown.
All right, Mr. Brown, you're here today because you're arrested for charge of trespass on a designated construction site and loitering and prowling. I'm not sure I can see the loitering and prowling. Because actually, he was on the construction site allegedly, but as soon as they asked him what he was doing there, he told them exactly what he was doing. Now, it might not have been legal, but I don't know that that gives rise to a, I mean, that should have swayed, you know.
Yes, Your Honor, but I believe there's also a presumption when they flee from sight of law enforcement, there's a presumption under the loitering and prowling, and it does state that he prompted him to jump the fence, and then he encountered the officer, stating he knew he shouldn't have been there, and that it wasn't a normal time.
Yeah, but I mean, like I said, as soon as they determine, otherwise, every time there's a burglary or anything else, there'd be a loitering or prowling, and I don't think there is. I think that's meant for something else.
I believe if there's, it's to stop the inception of a crime. Arguably, there was it stopped the inception of a crime. There wasn't a completed burglary, which is when we have a loitering. We can't have a loitering and a burglary because the whole point is to stop the inception. And in this case, it did stop the inception of an additional crime. It does state that it's a construction site that's been recently burglarized and often burglarized. And the employee stated that they are concerned regarding another theft after they heard him allegedly jumping the fence.
I understand that, but loitering and prowling, the law enforcement officer has to give the person an opportunity to dispel their, tell them why they're there. If they tell them, then it's not loitering and prowling. If they say, yeah, I was just here to, like in his case. That's to me, loitering and prowling usually is where they don't have a good excuse. This one is well, I mean, it's not a lawful excuse, but. All right, I'll set bond amount of $1,500 on count one, $100 on count two. Convince me. I'll appoint a public defender to represent you. If you do bond out, you're not to use or possess any guns, weapons, drugs, or alcohol, and you're not to return to the scene. You can't go back to where you were. Okay? All right, and the public defender, if you do bond out, make sure you call them when you get out.
Okay. Read that.
Read it now?
No, not right now.
Take this with me?
Yes, sir.
Your name, ma'am?
Kramer.
All right, Ms. Kramer, you're here today because you're arrested for a charge of sale and delivery of cocaine. I have read the charging affidavit. I do find sufficient probable cause. Bond be set in the amount of $2,000. I will appoint a public defender to represent you. If you do bond out, you're not to use or possess any guns, weapons, drugs, or alcohol. Your name, sir?
Jonathan Dean.
All right, Mr. Dean, you're here today because you're arrested for the charges of possession of methamphetamine, possession of drug paraphernalia, and possession of methamphetamine with intent. I do find sufficient probable cause as to count one, possession of methamphetamine, bond be $1,000, possession of drug paraphernalia, $100, possession of methamphetamine with intent be $1,500. If you do bond out, you're not to use or possess any guns, weapons, drugs, or alcohol, and I will appoint a public defender to represent you.
Your Honor, we'd ask to waive the reading.
Okay.
Fine. Thank you.
Your name, sir?
William Foster.
Mr. Foster, you're arrested today because you did not report as required by statute. I do find sufficient probable cause. Bond be set in the amount of $1,500. If you do bond out, you have 48 hours in which you need to report back in, okay? And I will appoint a public defender to represent you. You're not to use or possess any guns, weapons, drugs, or alcohol.
Yes, sir. That's all. Thank you.
Your name, sir?
Adrian Omar Gonzalez.
Mr. Gonzalez, you're here today because you're arrested on a charge of possession of controlled substance with intent to sell or deliver. I have read the charging affidavit, and I do find sufficient probable cause. Set bond the amount of $2,000. I will appoint a public defender. If you do bond out, you're not to use or possess any guns, weapons, drugs, or alcohol.
Yes, sir.
Your Honor, for this next client, before you make a decision on the out on bond, I'd like to be heard.
Okay. Your name, sir? Mr. Hamilton, you're here today because you're arrested for a charge of possession of cocaine. I have read a charging affidavit. I do find sufficient probable cause. We'll set bond the amount of $1,000 on that. I will appoint a public defender for you. If you do bond out, you're not to use or possess any guns, weapons, drugs, or alcohol. So he has an out on bond on a DeWillis and an out on bond on a possession of drug paraphernalia. What did you want to say?
Your Honor, it hasn't been filed on. I think it dates back to August 22nd. I understand that the argument may be that one of the charges are similar in nature, but with the driving while license suspended, Your Honor, he wasn't driving that. He was, I would say that one's similar. He wasn't driving, and in the vehicle that he was in, based on the affidavit, I think they were just giving him constructive possession. I know they said it was within his reach. We would just ask that you take no action.
Your Honor, it wasn't that it was just within his reach. He made furtive movements towards that area of the vehicle. Regardless, probable cause has already been found on that charge. The out on bond, we have not filed on the paraphernalia. It is from August. It is still with FDLE to get a test on that. However, the DeWillis is filed. He largely is DeWillis based on 893 suspensions. So this tracks in that same vein of 893 suspensions. So state is requesting that you revoke and at least double both cases, given his last conviction was also possession of cocaine about a year ago.
I'll take no action on this, based on what it is. Your name, sir? Your name? Okay, Mr. Huey, you're here for two cases. In the first case, 2025 CF 15079AO, charged with burglary of a conveyance with an assault or battery and criminal mischief.
And Your Honor, as to that case, state does have argument. And information was filed as to both of those counts. The Burke conveyance with assault or battery is a first-degree felony that's punishable by life. We're requesting that he remain at no bond pursuant to Arthur with no date set. And we'd ask that you stay count 2, the criminal mischief, at $2,000. This incident is from August of 2024. The alleged victim in this case is Ms. Kinsey. She is also the alleged victim in the other new law offense that Mr. Huey has. However, additionally, he is on probation, also for a case regarding Ms. Huey or Ms. Kinsey. He also has another felony case against Ms. Huey, and then 3 violation of PTR, bat DV, ag assault, or assault DV, criminal mischief cases against Ms. Huey. So there are 5 open cases and 1 that's currently in BOP posture, all the same alleged victim. State's not sure of any other conditions this court can place to ensure the victim's safety. I believe it's also stated within this affidavit that at one point he did state that he'll kill anyone that is a problem. And it wasn't until the stepdad interjected in this case was the defendant pulled off of the victim. So we are requesting he remain at no bond under Arthur with no contact with any victim's witnesses.
Your Honor, I'd like to respond.
Okay.
We have no objections to the conditions that the state would like to put in forth. No contact with the co-defendants, but As it currently stands, this is a enumerated dangerous felony under 907.041 that would entitle him to a PTD hearing, Your Honor. State's making argument to hold him under Arthur. We believe in a PTD hearing where he would be entitled to a hearing within 5 days. State can make these arguments downtown. They could go ahead and argue that there's no combination of conditions that would allow for the defendant to enter the public. But as it currently stands, it is an enumerated dangerous felony. He is entitled to a PTD hearing. We'd ask that you would honor that. And
That is absolutely incorrect. Burg dwelling is enumerated. Burg conveyance and Burg structure is not. So he is not entitled to pretrial detention. This is not an enumerated crime. Only Burg dwelling, the assault or battery, not Burg convey or Burg structure. So it can only be held legally under Arthur.
All right, in the 2025 CF 15079AO, count one, burglary conveyance, says I'm going to hold no bond. The criminal mischief will be $500. In 2025 CF 15081, count one, $5,000, count two, $2,500. In both cases, no contact with any witnesses or any of the alleged victims, no guns, no weapons, no drugs, no alcohol. And appoint a public defender on both. No return also. So if you do go back and maintain separate residence of all of those folks as well.
we'd ask to waive that appearance, Your Honor.
All right. What about Howard Jones?
Howard Jones refused. We'd ask to waive that appearance as well, Your Honor.
Appoint a public defender. What was that? On Howard Jones, as I said, appoint a public defender, set bond the amount of $2,500. No return.
Wendy's.
To the Waffle House. No contact with any of the witnesses or alleged victim. No guns, no weapons, no drugs, no alcohol. Jessica Jones, appoint a public defender. Possession fentanyl, $1,500. Drug paraphernalia, $500. No guns, no weapons, no drugs, no alcohol.
Jones LaShonda, Charity Bond.
Your name, sir? Mr. King, you're here today because you're arrested for 3 charges. The sale and delivery of a controlled substance, Schedule 1, possession of cocaine, and possession of drug paraphernalia. I have read the charging affidavit. I do find sufficient probable cause. To count 1, the sale and delivery would be $2,000. Possession of cocaine, $1,000. Possession of drug paraphernalia, $500. And I'll appoint a public defender to represent you. If you do bond out, you're not to use or possess any guns, weapons, drugs, or alcohol. Your name, sir? Mr. Luttrell, you're here today for a possession of a controlled substance without prescription and possession of drug paraphernalia. I have read the charging affidavit, and I do find there's sufficient probable cause. Bond, we set the amount of $1,000 on the possession, $500 on the possession of drug paraphernalia, and appoint a public defender to represent you. You're not to use or possess any guns, weapons, drugs, or alcohol if you're bond out. Your name, sir?
Luis Martinez.
All right, Ms. Martinez, you're here today because you're arrested on a warrant for failing to appear. And that was on your carjacking with a firearm. There is no bond on that. And it looks like the public defender's already been appointed, so you have a lawyer.
No. Thank you.
All right. I will appoint a public defender to represent her. Set bond amount of $2,500. No return, no contact, no guns, no weapons, no drugs, no alcohol. Mets.
You'd ask to waive that appearance, Your Honor.
Appoint a public defender to represent him. Possession of cocaine. Bond set $2,000. Possession of cannabis less than 20 grams, $500. Possession of drug paraphernalia, $500. Was there an out on bond? Refused. And no guns, no weapons, no drugs, no alcohol. Is he out on bond? Is there an out on bond on Mets?
Yes. You have it. Wait, 1 second. Robin, do you have a case number?
Yes, 2025 CF 7422AO.
Is that orange?
Let me see. They don't even have a note of it.
I think so.
I found it. It's just spelled different. Mets with an S versus a Z. In that case, the 25 CF 7422 that he's currently out on bond is a possession of fentanyl. It is filed.
Did he get 33 days out? Is that why there's no bond?
It's like an ROR.
Yes, he was 33'd in July. We filed in October when FDLE came through. Yes.
Revoke that bond and set a bond of $2,500. Okay. Your name, ma'am?
Medallion Morales.
All right, Ms. Morales, you are here today because you're arrested for the charges of accessory after the fact for first degree felony, false report to a law enforcement officer, and contempt of court. Let me make sure. All right, yeah. I think I had a question about the, oh wait, this is a, was this a affidavit? Yeah, I read it, but I don't know what the false report was. But hey, he already found probable cause.
Yes, Your Honor. Probable cause is already found. We ask that you stay that finding. The accessory regarding the first degree felony was an attempted felony murder and a conspiracy for attempted, I believe, robbery. Let me double check that. Yes, conspiracy to commit armed robbery, which are both punishable by life. So we are asking you to take that into account when setting her bond. She is currently entitled to bond. Count 1 is an F2. Given that it's F2, the schedule is usually anywhere between $75,000 and $10,000. We would be asking for that and for you to stay 2 and 3 with no contact with any of her co-defendants, Mr. Vidal, Mr. Toro, Mr. Ruiz Alvarez, Mr. Medrano Ramiro, and Mr. LeBron Nero.
Okay. On the accessory after fact, set bond amount of $7,500. I'll stay the bond $1,500 count 2 and $500 for count 3. No guns, no weapons, no drugs, no alcohol. You'd have no contact with your co-defendants. And is the public defender, they already get appointed or no? Doesn't look like it. I'll appoint a public defender. And surrender any weapon within 24 hours if you do bond out.
And in addition to co-defendants, we'd ask for witnesses or victims as well.
Yeah. Okay. Yeah, no contact with witnesses, victims, or co-defendants.
Thank you.
Your name, sir?
Morales.
I'm Mr. Morales here today because you're arrested for charge of battery on a uniformed or licensed security officer. I have read the charging affidavit. I do find sufficient probable cause. Set bond amount of $1,250. If you do bond out, you're not to have any contact with the alleged victim. You're not to return to the scene, and you're not to use or possess any guns, weapons, drugs, or alcohol. I will appoint a public defender to represent you. If you bond out, make sure you call them.
Just grab that, sir. Grab this form. Yep, that's yours.
Okay.
Yes, sir.
Your name, sir? Mr. Murphy, you're here today because you were arrested on a charge of grand theft, third-degree motor vehicle. I have read the charging affidavit. I do find there's sufficient probable cause set bond in the amount of $1,500. If you do bond out, you're not to use or possess any guns, weapons, drugs, or alcohol. You're not to operate a motor vehicle without a valid license. You're not to return to the scene or have contact with any witnesses or the victim. I'll appoint a public defender for you, so you have a lawyer.
You'll get an attorney. Just follow it. You have an attorney?
Who do you have? Oh, with David Webb's office? Yeah, Dave Webb, okay. And then I want to appoint a public defender. Yeah, I know Samantha.
Okay.
Your name, sir?
Isaiah Phoenix.
All right, Mr. Phoenix, you're here today because you were arrested on a charge of possession of a concealed weapon or firearm by a convicted delinquent and resisting an officer without violence. I have read the charging affidavit on the possession and find sufficient probable cause. Possession of a concealed weapon or firearm set bond amount of $2,000. Resisting an officer without violence, $500. If you do bond out, you're not to use or possess any guns, weapons, drugs, or alcohol, and you're not to have any contact with any witnesses or with the victim. I will appoint a public defender to represent you. It looks like you got a hold for Jax. Your name, sir?
Antonio Powell.
Mr. Powell, you're here today because you're arrested for sale and delivery cocaine, sale and delivery of methamphetamine, trafficking cocaine over 28 less than 200 grams, trafficking methamphetamine over 14 grams, and unlawful use of a two-way communication device. State?
Yes, Your Honor, and as currently charged, Mr. Powell is entitled to bond on all these charges. We would be asking for the schedule, at least as to counts 3 and 4.
What is the schedule?
50 on each.
Okay.
Usually 1 and 2 come in at 15. However, state has no objection to a subsidiary.
Okay. All right. I will set bonds as follows. On the sale and delivery, I'll set that bond at $2,000. And the sale and delivery of methamphetamine, $2,000. Schedule on the trafficking cocaine is $50,000, and on the trafficking in methamphetamine, $50,000. Unlawful use of a communication device, $500. I will appoint a public defender to represent you. If you do bond out, you're not to use or possess any guns, weapons, drugs, or alcohol.
So,
all righty, you're all set. Your name, sir? Hello, your name? Hi, Mr. Reeves, you're here today because you're arrested for 3 charges: possession of drug paraphernalia, tampering with physical evidence, and possession of cocaine. I've read the charging affidavit. I do find there's sufficient probable cause. As to count 1, possession of drug paraphernalia, set bond of $100. Possession of the tampering would be, huh?
Your Honor, this is I think those are the charges for Zachary Reeves. This
Yeah, that's what he said.
Christian. We'd ask to waive that appearance for Mr. Reeves.
All right, I'll appoint a public defender. Set bond 1,000 on count 1, 500 count 2, 100 count 1, 500 count 2, 1,000 count 3. No guns, no weapons, no drugs, no alcohol. What about Tony Roy? All right, your name, sir?
Christian Stabner.
All right, Mr. Stabner, you're here today because you're arrested on a charge of burglary of a structure with assault and battery and criminal mischief. State.
Yes, Your Honor, and as charged, count 1 is a first-degree felony. That's punishable by life. However, it's not an enumerated dangerous crime under 907. So we're requesting that he remain no bond on count 1 pursuant to Arthur, and for you to stay the bond on count 2 with standard conditions of no contact, no return.
Okay. Set no bond, count 1, $1,000, count 2. Want a public defender to represent you. If you bond out, you're not to use or possess any guns, weapons, drugs, or alcohol. You are not to return to the highways shop. What was it? Like that.
Highways Smoke Shop?
The highway smoke shop. You have no contact with the alleged victims and no contact with any other witnesses. And as I said, I appoint a public defender, so they'll come out and talk with you. Your name, sir?
Williams.
All right, Mr. Williams, you're here today because you're arrested for a charge of grand theft, 3rd degree, over 750, but less than 5,000. I have read the charging affidavit. I do find that there's sufficient probable cause. I set upon the amount of $1,500 on that charge. If you do bond out, you're not to use or possess any guns, weapons, drugs, or alcohol. You're not to return to the Waffle House at 5350 South Kirkman. And I will appoint a public defender to represent you on that. Now he's out on bond on a possession.
He is out on bond on a fleeing and petty theft in 9734. That case is filed. Given that it is also a theft-related offense and crime of dishonesty, state's requesting that you revoke. He's also out on bond on a possession of meth, cocaine, and paraphernalia. That arrest was in August. He was ROR'd on a 33 in September. State would request that you revoke and double.
Your Honor, we would ask that you revoke and double.
On possession of methamphetamine, possession of cocaine, I will revoke and double. On the fleeing, attempting to elude, and petty theft, I'll revoke and double. I don't know what that, it's 7,500, but I don't know what the breakdown is.
Give me 1 second. On the 9734, I believe it was 5,000 on the fleeing, 25 on the petty theft.
Okay, so that'd be 10,000 and 5,000.
And then as to 10780, that one was $1,500.
So 5,000, 2,000, 1,000.
Yes.
All right, can I just read these back to you, Your Honor?
Yeah, read them back to her because
I'll read them back to you.
that was on the fly.
1,500, 10,000, 5,000, 5,000, 2,000, 1,000.
Additionally, state does have motion as to the 15158, requesting it go to 10 with those two lowercase numbers.
Okay. Is granted.
Your Honor.
Yep.
Was Mr. Powell white? See, white Paul Douglas?
He was a move up.
He was a move up?
Yes.
Were we appointed public defenders? We were?
I'm sure if he didn't plea, yeah.
You didn't plea. Beautiful. Okay.
Yeah, so if he did, then. All right, Nate, your name, sir? Mr. Woodard, you're here today for failing to appear on your grand theft third-degree motor vehicle case. There is no bond on that. Is that? I don't know who represents. Oh, okay, yeah. Yeah, it looks like you already have the conflict office, the RCC. So you have a lawyer already. They'll come see you. Your name, sir?
Jesse Wyrick.
All right, Mr. Wyrick, you're here today because you're arrested for a charge of burglary with conveyance with assault or battery. And I have read the charging affidavit. I do find that there is sufficient probable cause. State?
Yes, Your Honor, and as charged, it is a first-degree felony that's punishable by life. We are requesting he remain at no bond pursuant to Arthur, partially concerned about his danger to the community and the alleged victim and the child present within the vehicle. We'd ask they be at no bond. Defense to file a motion when they're prepared for hearing.
All right, there'll be no bond on this case at this point. I'll appoint a public defender to represent you. If you do bond out, you're not to use, possess any guns, weapons, drugs, or alcohol. You're not to have any contact with the alleged victim, and you're not to return to 7853 East Colonial Drive. And that's that. You're all set. Thank you.
Okay.
Thank you, Judge.
Say his name and